Hello everybody, welcome to JURISCentral.com online classes for law exams. So today I will be dealing with you the Prevention of Corruption Amendment Act 2018 for your upcoming UPSC Public Prosecutor exam. So I will be dealing with you the important amendments which is done in this act called Prevention of Corruption Act. So let us start, and let me also tell you, like for UPSC Public Prosecutor exam, the acts which are important for your examination are, this is the first most important act, Prevention of Corruption Act, then Prevention of Money Laundering Act, then comes Delhi Special Police Establishment Act, then Central Vigilance Commission Act, and the last comes Information Technology Act. So I have already taken a session on the rest of the other except Information Technology Act, which I will be taking with you shortly. So first of all, let us see, and if you want to read the acts in detail, I have shared the link in the comment section below, in which I have already discussed the entire act, Prevention of Corruption Act, along with its amendment in that session. So we will be dealing with you only the important ones. So let us see what are those. First, we'll start with the introduction. The Prevention of Corruption Amendment Act 2018 came into force on 26th of July 2018. So it came into force on 26th of July 2018 and seeks to bring the Indian anti-corruption legal framework in conformity with current international practices laid down by the United Nations Convention Against Corruption, UNCSC. So this amendment has been done in conformity with the international convention called United Nations Convention Against Corruption. Key changes to the definition. The Amendment Act includes the following definition. First comes Section 2AA, which deals with the term called prescribed. Prescribed has been introduced to mean rules that may be drafted by the central government under the Act. So prescribed generally means that the rules has to be framed by the government, and it actually means that rules for organizations and companies to form internal guidelines and procedures to prevent its employees from affording undue advantage to public servants, and rules for prosecution of a public servant under the Act. So government can prescribe rules for the organization to to form internal guidelines and to prevent its employees from involving into undue advantage to public servants, and also it can frame rules for prosecution of a public servant under the Act. Then in Section 2 Clause D, the term undue advantage has been defined to mean any gratification other than legal remuneration. So gratification is nothing but, in simple terms, it is also known as bribe. The term gratification has been clarified to include all forms of gratification estimable in money besides pecuniary gratification. So it means gratification means every kind of undue advantage even if the form of property, and also which is estimable in money. The term legal remuneration has been clarified to include all remuneration a public servant is permitted to receive by the concerned authority. So legal remuneration has been clarified, like those remuneration a public servant is permitted to receive by the concerned authority, like his salary. Key amendments. Now we will be dealing with the key amendments which are most important for your upcoming exam. Under Section 4 Clause 4. Now I'll tell you, Section 4 of Prevention of Corruption Act deals with cases triable by special judges. The courts no longer have to complete trials for offences under the Act within 2 years, failing which the judges will need to record the requirement for extension in time. A trial can now be extended by 6 months at a time for up to a maximum of 4 years. So it generally means, like earlier in the earlier Act, the provision was that the court has to complete the trial within 2 years. But with this amendment, this provision has been done away with, and it is said that even under exceptional circumstances, the time can be extended not exceeding 6 months at a time and for a maximum period up to 4 years. Then exemptions from compulsion. Section 8, which deals with offence relating to bribing of a public servant, prescribes punishment for persons abating a bribe or attempting to indulge in corruption with a public servant. The Amendment Act exempts those acts committed out of compulsion, provided a person so compelled files a complaint with the police or investigating agency within 7 days of giving a bribe under compulsion. So generally Section 8 punishes those persons who gives or offers or attempts to bribe a public servant, but there is one exception given. Suppose if the person was compelled to give bribe to that public servant, then he will not be liable under Section 8, but it is given that he has to file a complaint with the police or investigating agency within 7 days of giving a bribe under compulsion. Now let us see the punishment. The person who has given bribe to a public servant not out of compulsion, he will be punishable with imprisonment for a term which may extend to 7 years or with fine or with both. Then commercial organization, Section 9 deals with offence relating to bribing a public servant by a commercial organization. Now specifically deals with commercial organizations and persons associated with commercial organizations. The term commercial organization is clarified to include all forms of business structures, and phrase persons associated with commercial organization is wide enough to include employee and vendor. So by this amendment, even commercial organization and the person involved with the commercial organization can be held liable for giving bribe to a public servant. And if I talk about the punishment for the commercial organization, then it shall be punishable with fine only, provided that it shall be defense for the commercial organization to prove that it had in place adequate procedures in compliance of such guidelines as may be prescribed to prevent persons associated with it from undertaking such conduct. But the commercial organization can take the defense. That means the commercial organization cannot be held liable if it proves that it already had an adequate procedure to prevent the persons associated with it from undertaking such misconduct. For the purposes of Section 8 and this section, commercial organization means, now we'll understand what do we mean by commercial organization. It's a body which is incorporated in India and which carries on a business whether in India or outside India. Any other body which is incorporated outside India and which carries on a business or part of a business in any part of India. That means a company which is incorporated in India or outside India but carries its business in India. A partnership firm, even a partnership firm also comes under commercial organization. Then any other partnership or association of persons which is formed outside India and which carries on a business or part of a business in any part of India. So a partnership firm, whether registered in India or outside India, is also liable. Then punishment. Section 10 deals with person in charge of commercial organization to be guilty of offence. So Section 9 actually, it makes the commercial organization liable for criminal misconduct, and Section 10 makes a person in charge of a commercial organization to be guilty of the offence of misconduct. Now imposes specific terms for imprisonment and a fine where the commercial organization's director, officers in default, or a person with control over the organization has consented to the corrupt act violating the provisions of the act. So under under Section 10, even a director, officers in default can also be held liable for violating the provisions of the Act. It may be useful to note that when amendments to Section 10 and Section 9 are read together, the amended Act seems to penalize both the commercial organizations for violation of the Act by levying of a fine and the officers in charge of such commercial organization under Section 10 for criminal liability. So if I talk about organization, it shall only be liable for payment of a fine, but if I talk about person in charge of a commercial organization like a director or officers in default, then they shall be liable criminally liable under Section 10. Then explanation: for the purposes of this section, director in relation to a firm means a partner in the firm. Now this is important. In case of a partnership firm, the director means the partner in that firm. Now we'll deal with the punishment. Such director, manager, secretary or other officer. So who shall be liable? The director, manager, secretary or other officer, and even the employee, its agents or vendor shall be guilty of the offence, shall be liable to proceeded against, and shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years. That means the minimum punishment given is 3 years and the maximum punishment is 7 years, and they also be liable to pay fine. Then corruption by public servants. The Amendment Act seems to have diluted the instances where a public servant can be accused of alleged criminal misconduct. This section is very important. Section 13 deals with criminal misconduct by a public servant, and it is believed that by this amendment, the earlier strict provision of Section 13 has been diluted, and now I'll tell you how. Because of the act only refers to the misuse of property and unjust enrichment as ground for misconduct. Earlier Section 13 accounted for general tendencies to seek bribes for indulge in corrupt practices as grounds of criminal misconduct. So earlier Section 13 accounted for general tendencies to seek bribes and indulge in corrupt practices as ground for criminal misconduct. But now this provision has been done, this grounds has been done away with, and it is given like the public servant can only be accused of alleged misconduct on the grounds of misuse of the property or unjust enrichment of the property which is entrusted to him. Then permission to prosecute by an investigating authority. The Amendment Act appears to make it more difficult to prosecute government employees. The amendment under Section 19 deals with previous sanction necessary for prosecution, states that for prosecution of a public servant under Section 7, which deals with offence relating to public servant being bribed, Section 11, which deals with public servant obtaining undue advantage without consideration from person concerned in proceeding or business transacted by such public servant, 13 deals with criminal misconduct by a public servant, and 15 punishment for attempt. Of the act, firstly, a sanction must be obtained from an authority that has the right to dismiss them. So now, the investigating authority cannot investigate any complaint of corruption cases against the public servant if it has not taken a sanction from the authority that has the right to dismiss them. Secondly, an investigating authority such as a police officer must seek an application for permission, or else there are multiple layers of compliances that need to be cleared before the court can take cognizance of the offence. And also by this amendment, now it has become difficult for the court to take cognizance of such offences at the same time, because there has to be because the investigating officer and the court has to take compliance of the multiple layers before taking cognizance of the offence. Important punishments. Now we will be dealing with the important punishments. Section 7, like already I have told you, offence relating to public servant being bribed. So for this, the person shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine. Then Section 11, public servant obtaining undue advantage without consideration from person concerned in business, in proceeding or business transacted by such public servant, and that person shall be liable with imprisonment for a term which shall not be less than 6 months, but which may extend to 5 years, and shall also be liable to fine. Then 13, very important, criminal misconduct by a public servant. Any public servant who commits criminal misconduct shall be punishable with imprisonment for a term which shall not be less than 4 years, but which may extend to 10 years. So the minimum punishment given is 4 years and the maximum punishment is 10 years, and shall also be liable to fine. And Section 15, punishment for attempt. Whoever attempts to commit an offence referred to in clause A of subsection 1 of Section 13, the clause actually deals with dishonest misappropriation of property which is entrusted to the public servant, and he shall be liable with imprisonment for a term which shall not be less than 2 years, but which may extend to 5 years, and with fine. The Section 15 deals with punishment for attempt. So this is the session for today, and I hope you all have liked it. Do not forget to give a like, share and subscribe to the channel. And only one subject is left, which is Information of Technology Act, which I will be, the questions of the same I will be dealing with you in a day or two. And also let me tell you, like I have already discussed the previous year question papers of the year 2017, 15, then 2010, 2011, and also I have taken sessions for Delhi Public Prosecutor exam of 2010, 2008 and 2005. In all those sessions I have discussed in detail the solved question paper of this exam. So I would suggest you to go through those sessions so that you can have an idea what kind of questions you can expect this time. And you would find the link in the description box below. So with this note, I am signing off. Have a great day.